guess. Yeah. Good morning, and glad to hear it's cooler and less humid in Florida, which is kind of the same here. It's cloudy. We'll be outside in a few minutes after we do this stream, and then also we'll have a member stream after this on some details on the Allen case. But let's roll through what we've got so far. This isn't a whole lot this week, but some interesting points. We'll start off with our good friend Darrell Brooks here. Big money Brooks, babbling Brooks. Just look at him. He's so stoked. Life's a little different for him now, but at least he has glasses. So follow up on his civil suit a little bit on the docket. Nothing else has been filed yet, but this case isn't but so substantial. Some people have mentioned before in the comments, which I agreed with, that this was likely some kind of underinsured, uninsured case, but I didn't have the data then. Still don't have a copy of the complaint, but I did find the news sources, so I wanted to follow back up and report on that. So this is the family's automobile insurance coverage for uninsured and underinsured, and they're having a dispute over how much that's paying out. So that's why this lawsuit is there. And the attorney mentioned that they hoped it would just settle out, which I'm sure they're wanting them to tender the limits. So it's not so unusual. Hello to Thailand, all the way across the world, but a very beautiful country, that's for sure. Denver, nice, excellent. California. And close to home, Charlotte. All right. So we got some cool people here, that's for sure. Let's look at how the cookie is crumbling for the Crumbley family. Not good news for them in court. You might remember the son. He's in the middle there. He went to school and killed some of his classmates. It was a terrible, terrible situation. He kept kind of a diary leading up to it about his clear intent to do it. Certainly a kid who was mentally disturbed. There's no doubt about that. And that's part of what has gotten the parents into hot water with the legal system right on the ragged edge of responsibility for what they're charged with is manslaughter. So Ethan lost his effort to avoid life without parole. He had a special hearing due to his age. I think his final sentencing is in December, and it looks like he's going to go away. Now, his parents have been fighting against the charges they have anyway, which is manslaughter. And it is on the ragged edge of that, because I mentioned here, without reading all the words, that typically for your actions to cause you to have legal responsibility in a civil or criminal context, you have to be the proximate cause of what happened. And proximate cause is not the same thing as you actually caused it. It's like a legal limitation of clause. And what they're saying here is that the law normally says that if the intervening person, here their son, engaged in an intentional criminal act that breaks the proximate cause chain, that it's not, the law says it's not reasonably foreseeable normally that someone will commit an intentional criminal act. So if you did something that put something into a chain of events into reality, that then somebody steps in and then actually causes the harm, you're not responsible for it. But the Court of Appeals examined that and said, no, in this case, we think we're not going to find as a matter of law that there's no proximate cause. The parents did lots of things that we think are bad, and they had a specific amount of knowledge about the son that would make it reasonably foreseeable that he might, or could make it reasonably foreseeable that he might commit a criminal act. That's on the ragged edge of the law. And in fact, the Court of Appeals even said this isn't precedent for any other case, which is usually a signal that they're doing something special or something off the beaten path, which I think they have done here. Now, the parents are bad parents and they deserve some culpability in this. Whether that's the right charge or not, though, I think is interesting, because certainly you don't want to be just changing the law on proximate cause because of a bad case. Some other states have other charges, and I think they did here too, that they could have used that don't involve the issue of the proximate cause, because they're not directly charged with manslaughter. So at any rate, they asked the Michigan Supreme Court to look at this case and review it, and they said, we're not going to do that. And normally you don't look at these kind of things before a trial, so I don't think it's too surprising that they didn't get that review here. It doesn't mean that they wouldn't win later if they are convicted. It just means they're not going to have the chance to go before the state Supreme Court at this point. So California is going to be 96 degrees. Yeah, that's quite warm. It's not going to do that here. And then we'll be up in the mountains in a couple of days. Well, in a day where it will be cooler. Do I think they're guilty of it? So I do think, I think they're culpable for what he did to some degree. because they left the gun unsecured and they knew that the child was mentally disturbed. I mean, really mentally disturbed, not like slightly mentally disturbed, and some of the other bad facts and things. So my position is that if you have firearms, you have some responsibility to use them well and to store them correctly and do things and stuff like that. I mean, I'm about as pro Second Amendment as you can possibly be, but I don't think they did the right thing here. I think they made the tool available. But I can see, however, the point of some of the lawyers who say this is too far, though, for manslaughter, that there are other laws that they could have been charged under that don't basically accuse them personally of the murder, that they didn't know he was going to go into school and shoot these people. And I think that's a good point. So I think they have culpability. What the level of that is remains to be seen. And ultimately, it's going to matter what the judge and the jury decide, of course, in that case. So we will see. Good morning to Judy. Boy, she's been putting out some awesome content, but a case that she's been watching carefully, the Adelson case, is coming up for trial soon, and a lot of interesting legal maneuvers going on there and things with witnesses and stuff. So again, encourage you to watch it, not only for the stuff that she's doing in terms of the content, but she puts on some pretty exciting presentations when she chooses to do so. All right, let's see. I feel they should be held accountable. Yeah, me too. And, in the case, say in Virginia, where the mother left the gun where the kid got in, went to school, shot the teacher, but she survived, she was held accountable, but not for, obviously not for manslaughter because the person didn't die. But they had other laws that they charged under, and she said, look, I shouldn't have done that. So I get all that. All right. So that's what's going on with them. Not a good time in court for them recently. As you can see from the expressions, they probably aren't any happier now than they were when those mugshots are being taken. So let's step off of their case for the moment. And this is a dangerous precedent. Now, remember, and I hear what you're saying there. Of course, however, the court says this isn't precedent. So if you try and cite that case in the future, you may have some issues with that. But I get what you're saying. It's right on, as I say, the ragged edge of the law. And many lawyers will say, well, it went over the ragged edge of that. Like, this is supposed to be the normal standard. That if there's an intentional criminal act, that breaks the proximate cause chain. So I do get that feeling here. I totally understand it. And maybe they should have been charged with something else, and this just wouldn't have been an issue in the first place. But it's not to say that the issue's over, of course, because, if they were to be convicted, then they could still appeal it again at that point. But we'll see what happens. That's what's going on with it. It is definitely it's certainly not a case that falls clearly within the law, right? Even the Court of Appeals struggled with that and called their own decision not precedent, even though you could argue it is some kind of precedent. So that kind of tells you what the status of this is, that it's on the margin. So let's head out to Richard Allen's case, because his attorneys have filed things that have gotten his case into the media a lot. And of course, talking about the Odin stuff. So we'll hit that a little bit. He's got an active defense team, which is good, and which he should have. So the Odin story has intensified, and they have filed additional material saying that the professor that allegedly said that, hey, I don't think this is a ritual scene or ruins, according to what the defense says the state witnesses told them in depositions, was eventually identified by the state. And then the defense has some kind of tape, I guess, of him talking to the police, and where he goes, yeah, no, I think it probably did look like somebody copying ruins. That's definitely somebody's attempt to copy ruins, at least as he understood the scene. I don't know how much exactly he's seen about it. And he says what he would imagine, or he could imagine, that's what somebody thinks that they should be doing if they want to be doing some kind of ritual involving sacrifice. So if he said that, that's contrary to what the state witnesses said in their previous statements, all according to the defense, of course. So we'll have to see how that goes. But I guess what I want to clarify here is not so much the Odin stuff, because we've all talked about that a lot, and what you think about it, but how is it going to impact the proceedings, right? Because that's kind of what this channel is a little bit about what the law is doing on this. So the context that this is coming up is the Franks hearing that they're requesting. And that's an attack on a search warrant that the police used to search Allen's home and his vehicle. So that's what all this is. This isn't some motion to dismiss the case because, oh my God, we found out, who really did it. Although they lay out a lot of what they think out in that motion, this is specifically to attack the search warrant. So into the Franks hearing, they have two things they have to do. First, they have to show a material lie in the search warrant. And then they have to show that there would be no probable cause. The judge would not have found probable cause without this false material. So if the judge looks at it and goes, well, you say, because they're supposed to show in their motion the specific things that the state lied about that they think would cause no probable cause. If the judge looks at that and goes, we know even if they did lie about that, the warrant still would have been issued, then you don't even get the Franks hearing, right? The Franks hearing will come up to establish whether those lies occurred and stuff. So the judge has to consider this. So the judge can say, well, let me look at what you say. And if that would have affected the decision on probable cause such that it would not have been found, then let's have this hearing and see whether this matters or not. So to me, the things the judge really ought to look at that, this is just my opinion, the judge does whatever she wants, or the timeline points, because that was really the basis for the probable cause, right? That Alan said he was there between 1:30 and 3:30 is what the probable cause affidavit says, that the girl saw him, he saw them sometime after 1:26. Then you have the female witness who comes on. She doesn't see anybody. Alan says he doesn't see any other guys. The juveniles don't see anybody else. And so the theory is that's him on the bridge at around 2 o'clock when the victims get there. So that's the sequence. So attacking that and saying that the state either lied about it or didn't tell the judge things that were so important about that it amounts to a lie is relevant to a Franks hearing. That's not the same thing as saying they did do that or they didn't do it. My point is conceptually what matters to a Franks hearing. And that's why I think this Odin stuff is thin for this kind of hearing, in my opinion, because whatever they may make out of it later, if you're going to go get a search warrant on somebody, the concept that the police don't discuss with the judge alternate theories that they've decided not to pursue, even if they're wrong or whatever, that all has to be disclosed in a search warrant would essentially cause the judge to become like an investigation overseer before any search warrant is issued. I want to know every tip that came in. I want to know how you sussed out those tips. What if there's something other than this Odin thing? I mean, people also thought that Ron Logan did it, right? And there's no extensive discussion of that in the probable cause affidavit. People have blamed the family. People have blamed other specific people. Should the police have to itemize all those things out and go, well, here's why we don't think it's this. Here's why we don't think it's this. Here's why we don't think it's this. Because before Odin came out, I've been peppered with comments about people who are absolutely certain that the evidence proves particular people did it. And I'm sure the police have gotten tips about all those people. So if you think about it practically, that's not a workable procedure for search warrants. So you look at the affidavit, what they told the judge amounted to probable cause, and did they lie about that or omit something about that? So I think the timeline issues are on point for that. The Odin stuff, I think, is less so, in my opinion. So that is not to say whether the Odin stuff has merit or not. I'm talking about conceptually what matters for an attack on a search warrant, right? And I think the standard that, well, we have to discuss all other theories that we've had or any other theories that we may have discarded earlier in the case is really probably not going to be accepted as the Frank standard. And they may know that, but they may disagree too. We'll see what the judge does, but that's my theory on it. So that's not to say that, again, that the Odin stuff isn't interesting, because it is. And maybe it'll be relevant, but I don't see too much of that for the purposes of the Franks hearing. But what else though? So what are we doing here? What's the point of this? So if they were to succeed in this Franks hearing and get this search warrant ruled invalid, then you probably would have, because since it's based on police misconduct, you would have exclusion of the evidence under exclusionary rule, right? So the results of the home and the vehicle search could be tossed out, or would be tossed out likely, because there's probably not going to be an exception that applies, I don't think. So that, I think, includes, for example, the SIG 226 that they took that was Allen's. And that's the only alleged, that I know of, forensic link, okay, to somebody in particular to the crime scene, because they say the round that was found there matches this gun, and he had possession of the gun at the time and nobody else did. So if that's true, right, then getting that gun excluded would be a big deal for the defense, right? So I think that's what they're aiming at. There may have been other pieces of evidence found in the home that matter. I just don't know what they are. So the other thing, of course, they'd want to attack the confession. And they mentioned that the Odin guards, were intimidating him into confessing. I don't know his mental state at the time he made the statements or anything else. So I'm not going to say that his confession is valid. And I don't even know what he said, right? But I'm also not going to say it's invalid. And I'm also not going to sit here and not look at them with a side eye when they start telling me that this Odin conspiracy stretches all the way across the state and includes the prison guards and all this stuff. I don't know about that one, but also, can understand why they want to say that stuff, because I don't think the law would support his inculpatory statements to his wife made months later. Probably wouldn't succeed in getting that suppressed, even if you got the warrant thrown out, although they would try it as fruit of the poisonous tree. So I just don't think that would happen, but they'd be remiss not to try. So if they could get the confession thrown out and they get the gun thrown out, then that's a lot, right? So that's my point on that. And let me make this point here, that I did send a sticker. So hopefully Customs will send those to you, and you'll have them soon. We sent them last Saturday. All right. What about at trial though? Okay. Can you use this stuff at trial? Because for me, that's maybe where this Odin stuff is more relevant, because it's relevant on social media. People are looking at it like, oh my God, did these other people do it? Right. Or does this exclude Alan as having done it because he's not some kind of Odin guy? So at trial, the scene characteristics, I think they're definitely relevant, right? This is a bizarre scene. What connects him to it? What disconnects him from it? It's a little different when you want to talk about an alternate perpetrator. You want to say this other guy did it. This other guy did it. And this person has been named by a lot of people as he either did it, participated in it, or used his minions, as they said in the motion, to conduct these crimes. So Indiana had gotten fairly permissive on that with a case a while back. I think it was called Joyner, where they said, look, evidence that somebody else committed the crime is certainly relevant under Rule 401. And who could disagree with that, right? That door was kind of wide, though, compared to some other jurisdictions. And he kind of shut it a little bit by saying in later cases, yeah, okay, but you can't just start blaming somebody else and pointing the finger at a specific person at a trial to cause this trial to go off the rails. You have to have some kind of material connection between that person and the commission of the crime. They actually had a case where the person who they wanted to blame for it had said about the victim, so-and-so is going to die. Had said that a few times, and they're saying, see, they had the motive, they did it and stuff, but they didn't have evidence that connected them to the actual crime of the scene. And the court said, well, without that, under Rule 403, we're going to say, no, you can't bring that in. So it's not a wide open door. So I know sometimes the idea might be they can say whatever they want in their own defense, including blaming anybody that they want to, but the judge has control over that in terms of what theories can be brought up. I think that was subject to some of the fighting in the Zachariah Anderson case, right? Blaming a specific other person. So they can keep it from becoming a circus to some degree by doing that. But on the other hand, if the defense has something real there, they should be allowed to present it. So there's a little bit of a balance there. Let's see. Take a look at some comments here. I think there was an idea that maybe I'm not responding to those, but I do try to. My mind's not as nimble as it used to be, so I don't like to lose track of what I'm talking about too much, even though I enjoy reading all the comments. Vero Beach, Florida. Very cool. Sucker for locations. Is there a timeline a judge has to make the decision? I haven't seen on the docket yet that's been set for any hearing, and it's pretty much just up to the judge, right? So I mean, sometimes you can calendar those things, but I haven't seen that calendared. I don't know that it isn't, so I'm not exactly sure when that will happen. So I don't know the answer to that. But my point is that you have currently an attack on the search warrant, and that is a specific kind of thing legally, right? There are only certain things, even if you have this great other stuff you might use later, that are really relevant to that kind of an attack. And in a trial, you might have a broader option to defend yourself, but it can't just be anything goes. It can't just be, I'm going to name this person and use immunity from libel in court to, say things and stuff like that. You're going to have to show the judge, well, what connects this person to this, and convince the judge. And the judge has some latitude there. So I don't think any of us can say for certain what the judge will or won't allow. Santa Fe, New Mexico. That's a cool place with the cool vibe. All right. I'll answer this one. Mrs. Southern-in-law is a medical professional and is my advisor to stop talking about intricate legal things like certain particular evidence rules out of context to cases because it's super boring. So she's the person who keeps that from getting off the rails too much. All right, we're coming close to the end of this one, I think, unless there's some other questions that I do know the answer to. I want to end it with a not really an unsolved case, but at least currently a solved one, and because the person is an idiot. Hello to Melbourne, Australia. Very cool. Don't know that I'll ever get there, but I know that it's awesome. It's just so far away. And I know continents drift, but I don't think it'll get close enough for me to hop over there anytime soon and within my lifespan. So everybody probably knows who this joker is, right? Craig Ross Jr., who is under arrest currently for having kidnapped a young girl away from a campground, away from her family, and holding her for a couple of days. And we don't know anything about the circumstances she went through. Everybody was concerned about it. I did not think she would be found alive, okay? I just didn't think that was going to happen. So we actually, when we were downstairs seeing this on TV, when they broke this news that she was alive, I mean, we don't know these people, right? But like a lot of people, it was like you personally felt this sense of relief, like, thank God that they got this guy. It's awesome. However, here's a place where he lives, right? And this could clue you in here. You may not be dealing with potentially a galaxy brain. Not only his picture of, if you wanted to draw a picture of somebody who looked like they had just kidnapped a young girl, this would be a pretty good effort, right? This would, if I were the teacher of that class, so this one would be an A, and would probably be my exemplar going forward, right? That student would be get a reverse apple. I would give that student an apple from the teacher if this was what they drew, to say, here's what I think a kidnapper would look like of young minor victims. And then if subsequently that student were to say, here's what I drew in my mind that I think a person, where they would live if they did this would be this too. This certainly looks like a place where somebody who wants to kidnap people would take them. I know they can be in mansions, boats, fancy places, cheap places. There's no limit on depravity, right, by socioeconomic status. But if you want to imagine things, take a look at this. This is where he was, I think. I hope I have that right. I don't want to slander anybody else's camper that they turned into a full-time living space, but I think this is the correct one. Well, you probably all know the ending of this story, at least as it stands right now, is the ultimate fail. He decided he wanted some kind of ransom from the family, and then transports a ransom note in his vehicle and personally puts it into their mailbox. I get it. You don't want to trust the post office, and it could take a few days to get there and stuff like that. So he personally delivers it and then leaves a fingerprint on this piece of paper. Now, there'll be somebody on some corner of the internet that can say, oh my God, somebody might have borrowed that paper from him and it already had his fingerprint on it. Or, oh my God, that he was set up. Except we all know that when police processed the fingerprint, they knew who this joker was, and he went to his camper and they were able to rescue the young girl. I know he's being examined for other crimes, and his neighbors have some really nasty stories about this total loser. So I'm glad he's caught, and that nothing worse happened, right? And then maybe they'll take this seriously, because the mindset this guy has, he either has done worse things or he might do them in the future. And I think, he's not going to be losing a lot if he goes out of his camper and goes behind the bars at the Gray Bar Hotel and can stay there, which is where I think this guy belongs. So let's see. Yeah, respect the hustle. Yeah, I mean, he was gunning for some money. Didn't work out for him because he's a total idiot and evil criminal who's willing to abuse children. So, life didn't maybe deal him the best hand. Just looking at his expression there, I don't think he was out breaking new theories in quantum mechanics, things like that. I don't think he was really at that level of speed. And apparently it didn't occur to him that maybe I shouldn't put my fingerprints on this piece of paper that I'm going to leave in this mailbox for ransom. But I'm glad that he did. So let's all thank God that at least some of these criminals are so stupid that they can be caught quickly. And in this case, caught quickly enough to save the life of this young girl back to her family, who love her a lot. And, nobody wants to be but so paranoid. But, you think about this. She goes to ride one more loop around this campground, which is populated with a lot of good people. And this guy's able to snatch her out and not be caught right away. So, we have some campgrounds like that in this state, of course. And, you would expect everybody in there to be decent people. And if they see something like this going down, the alarm would be raised right away. So this guy was able to slip through that net. And that's how it happens, right? And so many kids fall prey to this. It's too many. But But this one had the best ending that probably you're going to get out of something like this, even though it still is absolutely terrible. Really great that that she made it home. So this is it for this week. In a little while, about a half hour, we'll do a member stream on the Richard Allen case, going all the way back from the beginning to current and all the things that are going on. And maybe I can get a video out on this later in the week about the piece of forensic evidence that does exist, which is the 40 caliber round. And some people just know that it's not significant at all, and that's ridiculous. And some people know that it completely proves he's guilty. That's pretty ridiculous too, because nobody knows the quality of that evidence. But still, will it be admitted and things like that? I've got a video for that. I'll hopefully get it out later. So thanks, Judy. I appreciate that. And I'm hoping everybody has a good weekend, and we'll do this other stream. And then we got to pack the Harleys up and head to the western part of the state and ride around some and go up into the mountains. So let's see here. Well, that's it, everybody. I really appreciate it, and talk to you later. Thanks. Bye.